Can you hear me? Okay, there we go.
So there's three.
No, Richard's not. He may Zoom, but he's in the Bahamas. All right. Thank you, everybody, for being here. This should be the last meeting of this group this year. Marnie, can we have the called order roll call?
Okay. Member Black is not attending at this time. Committee Member Lalonde.
Present.
Committee Member McVeigh.
Here.
Committee Member Roth.
Present.
Committee Member Young.
Here.
Vice Chair Rapinello.
Here.
And Chair Harris.
Here.
We do have a quorum.
Just for everybody on the internet, we weren't expecting Richard Black to be here. He's working in the Bahamas this month, and if he can internet in, he's going to, but we thank him for his service if we don't see him until after this meeting has been concluded. Thank you. At this point, I'd like to open public comment. Do I have any public comment? Sue Miller, please approach the podium.
Sue Miller, Lower Matacumbe. I appreciate what you're doing for our community. I think it is really important, and it's disappointing that there aren't more people from the community participating with you, because I think that what you're doing right now is could be as important as anything that we will do in the next year or so. And I hope that by the end of this meeting, that the staff will have a list of all the accomplishments, all the things that we will be able to see on our ballot come November, if approved by the Village Council, and all of the recommendations that you are making to the council that should be addressed some other way other than the charter, because I know you've said, well, that should be handled some other way. I went to a meeting last week with a group of private property owners from throughout Monroe County talking about what can we do about traffic. I was the only one in attendance north of the 7 Mile Bridge, so I got an earful about what's wrong in Alamorada. And I've been thinking about, is there something that we can do to alleviate some of the traffic issues? And I find that it appears to me that anytime traffic is discussed, when we add new development or do anything approving something that might generate additional trips, we don't take into account what the impact will be on traffic. We always seem to blame the traffic problems in Alamorada as being something that happens because those people are going south. We're not generating that traffic. And I think that hearing from people south that are complaining about Alamorada and our lack of action to help with the traffic, I think it's something that we should think about as we see more and more permits coming in to build from property line to property line, and bigger and better always, that it does have an effect on the traffic, and we do have some part of the blame. And shouldn't we, the residents, get a vote? And even if we vote against, I think that it would make us feel better if you proposed a charter amendment that impacts how we handle traffic in Alamorada. And specifically, what they were talking about is that we are the only jurisdiction of all the local governments that do not require mitigation if we run out of available trips in any traffic segment in Alamorada. Every other jurisdiction requires mitigation once the trips on the level of service traffic study shows that they fall below the level C, then they have to mitigate in order to build more non-residential development, and we don't. And so why not? Why are we the only one that excludes that? And I think that while it may seem to be something that the council should decide in our LDRs, I think that traffic issues are so important to the people of this community. I think they deserve the right to vote on something that might help the Alamorada traffic situation, because no matter what we say about the traffic is just going to Key West or going to Point South, we are the bottleneck. And so I think that a proposal to change that so that when a traffic segment in Alamorada has no more available trips, that we should require mitigation, and we should define what mitigation means, and it should be in the charter so that the people of Alamorada can feel like they had some say in improving the traffic in Alamorada. Whether it works or not is another thing, but I think that it, it's done in every other jurisdiction. Why not here, where we have the worst problem of anywhere in Monroe County? Thank you very much.
Thank you, Sue, for your comments. I got another taker. Come on up.
I don't want to jump in front of anybody. Yes, my name is Joe Wishmeyer, and I must apologize. This is the first meeting that I've actually made, but I do also have the same concerns about traffic. I live on Plantation Key, where the road goes from 4 lanes to 2 lanes. Now, this construction certainly didn't help at all, but there's always a bottleneck right there. And as far as when we do traffic studies or when there's new building going, I went back and referred to my notes because I usually write down my public comments. And at the county commission meeting on May 20th, this was after Bart Smith had even done a presentation about the Publix that's on county property, but it's going to add over 1,600 trips a day on Plantation Key. Now, we can ill afford to have that, but here's a project that's not even associated with the village that is taking all the trips that we have. He did say for the extra trips over the allotted that they were going to pay $11,000 per trip in mitigation fees. Now, they said they were going to do that towards freebie, but they are at least doing a mitigation. But they're not even building in the village. So by requiring some sort of mitigation in the village, I don't think is really going out too far, trying to control this traffic situation. If we have new businesses that want to come in to Plantation Key, how are we going to do that when there's no more available trips? So I would hope that even in the charter, it should say something about, the county can't just come in and take over all the available trips that we have on certain areas just because they have a project. So then that kind of puts the burden on our businesses or our residents who want to build something and want to add an extra trip, and supposedly there isn't any left. So the traffic is really my big concern, because I'm stuck right in the middle of it. Thank you.
Thank you, Joe, for your comments. Marnie, do we have anybody online?
No, sir.
Thank you. So it's not on the agenda, but we kind of left it hanging at the last meeting, finishing up the discussion on whether or not we want to make a recommendation related to the millage rate and when there's a trigger for when it should go to a referendum. Saying, you got to tell me, Susan, so I don't do that. The legislature apparently has not addressed that at this point because we had put that off several times when we discussed it so that we had a little more information what was going on at the state legislature. Anybody want to revisit that, or are we going to just leave it as it is?
I'm for leaving it as it is.
I agree, but I want to hear everybody before we.
Do we have to approve minutes?
I think we had tabled it for tonight. With the two items I recall that we
No,
were.
Craig is just saying, do you want to do a motion to approve last meeting's minutes before we
I'm
have this
sorry.
discussion?
Yes, I'm jumping ahead, aren't I? Sorry, guys. Yes, can I get a motion for approval of the minutes?
Motion to approve?
Second.
Can you call the roll, Marty?
Committee Member Lalonde, or excuse me, Committee Member McVeigh,
Yes.
Committee Member Young,
Yes.
Committee Member Lalonde,
Yes.
Committee Member Roth,
Yes.
Vice Chair Raffinello,
Yes.
and Chair Harris.
Yes.
That motion passes 6-0.
Thank you, Craig, for keeping me on track. Okay, back to the item that we were discussing before I skipped over the minutes. Is there any appetite for talking about, discussing, making a recommendation towards the millage rate or leaving the charter language as it is at 5?
I would be open to its removal in its entirety. It seems like an artificial hurdle to the referendum process that otherwise exists. I can't say that I have overly strong feelings about it, but it would either be remove it in its entirety or leave it as is.
I've got no problem leaving it. You know, I think it's put in there way back when for a reason, and at least it's, gives something for the public if they want to do something.
Well, it actually restricts what the public can do. So if it wasn't there at all, the referendum could be had if the public disagrees with whatever millage rate is set by the village council. But if only it's above 5%, then they can't have the 5 millage, they can't have the referendum.
My understanding, correct me if I'm wrong, if you remove that 5 mils, they have absolutely no way of requesting a referendum.
But there is no then limitation to them requesting a referendum. What is the limitation on the referendum power?
I don't think you
without
have referendum power. It's specifically removed without that language.
No, what I'm saying is the in that case, I would definitely want to leave it, right?
Exactly.
But if that didn't exist, what I saw was a limitation. Let me look at the language again.
Yeah, you got to read it.
What's the section again?
It's an exception to
John Zone.
yeah.
John Quick is online if you care to hear from him.
Sure.
John, can you weigh in?
Sorry, yeah, I'm trying to find the language. What is the specific statutory section or the charter section?
John, we can't hear you.
Can you hear me now? Hello?
Referendum. Yeah, section 9. I printed mine before the. Yeah,
Provided that nuisance power shall not extend to annual budget or capital program or any ordinance appropriating money
Okay, I see what you're saying. Okay.
Mr. Chair, it's Lynn Tipton from the league.
Then you get your right to referendum back.
Fair enough.
So that's the stopgap.
That's the B and C.
Is that enough? Is it too much? Is it too?
It's enough.
In my opinion, I wouldn't want to remove it. I wouldn't want to go higher.
No.
I don't know that you necessarily want to go lower. And we've also been told that this is unique to our charter.
Lynn
So-
Tipton is
Which I don't
available.
understand why we're unique. It
Lynn.
seems to me that this should be more of the norm and not the norm, but nevertheless.
No, thank you for that, Joe. That was a big point.
Lynn, are you on?
Yes, I am. Can you hear me?
Oh, we don't
Barely.
have you.
But do other jurisdictions have the limitations set forth in B?
From what I've read, I've seen a lot of.
Can you hear me?
Lynn, you're
Lynn, you're still
muted.
very low volume.
Then I would just say I concur.
I've put it at max
Yeah,
volume.
with the
Can
leaving.
you hear me now?
Are you guys able to hear me too now?
They're not going to.
Well, so for purposes of discussion, while we're waiting on Lynn, do I have a motion to keep the language as it is? So for purposes of discussion only?
I make a motion to keep the language as it is with regard to the referendum.
Yeah, I'll second.
Thank you. So do we have Lynn?
Can you hear me?
No.
I'm showing full microphone. Can you hear me?
You're still very low, Lynn. Frank's working on it back
Okay,
in
so
the-
while we're waiting on Lynn, let's open it up to the public. That way we're not burning time. Do we have anybody from the public that wants to speak on this issue?
There are no hands raised on Zoom.
Sue?
It obviously is confusing, or you wouldn't be talking as if you don't know what it actually does. And so I think that even if you want to leave it, it should be clear to everybody what it means.
I think the confusion was simply mine.
Yeah, the rest of us were quite clear.
Listen,
mine.
every once in a while, Susan has to have some kind of memory lapse. So we'll give her a break because she was pretty dialed in on this the last couple of meetings.
So if she is confused, could somebody else explain it to me what it means?
No, I don't think Susan's confused at all, but I'll let her speak for herself.
So what it means is that the electors of the village would have no power to require reconsideration of any budgetary items to include the millage rate unless the village went above 5 mils, in which case if the village went above 5 mils, the referendum right would exist.
We don't want to take out the power for us to have a referendum if we went over 5 mils. And so if we leave the language as is, that power remains. So that's the motion that is on the floor and it's been seconded. Do we have Lynn?
I think John
think
was trying to
Frank's
speak
working
too,
on
but he
it.
was really quiet, so I think there's some.
The same can hear it at home, it's just the chambers. Steve Green just called, said he can hear it fine at home, so with the chambers we can't hear. So
I remember Lynn's comments on this from a couple of meetings ago where she basically had surveyed the number of jurisdictions that had similar language, and there are very few, if any, other jurisdictions in Florida that reserve to the people the right for a referendum if there's a cap and a millage rate where you exceed. So we're unique in that respect, and it leaves the power with the people, and I would fully support leaving that language alone. And we have a motion and a second on the floor. Arnie, could you call the roll?
Committee Member Lalonde?
Yes.
Committee Member Gabay?
Yes.
Committee Member Roth?
Yes.
Committee Member Young?
Yes.
Vice Chair Raffanello?
Yes.
And Chair Harris.
Yes,
That motion passes 6-0.
thank you. Now we're
Mr.
back.
Chair, can you hear me?
We got you now, Lynn.
And I'm so sorry. I've been trying the last couple of minutes. If you see John's note, he was worried it's in chambers. I could hear John. John could hear me. We couldn't get through to either of you. I do apologize.
It's
okay.
important
That John review your language, because what I'd shared with you, not only are you unique, there's an AG opinion, and in chapter 205 of state statute, a municipality may not in any way limit a council or commission's ability to set its millage rate. And that's what I had tried to share, is I wanted Mr. Quick as the attorney to review that, because I did not want your language to not conform with state statute in chapter 205.
I guess it really wouldn't become an issue unless we went over 5 mils, and then there could be a discussion on whether or not that provision is still consistent with Florida law. I don't think that changes anybody's mind about leaving it the way it is.
No, and I don't think.
But that's what I was trying to weigh in on, and I'm sorry.
I appreciate it. You had mentioned that at the last meeting, so duly noted. So at this point, I think we're on to the first item for discussion that's on the agenda, which is review and discussion and proposed language for recommendations to Village Council. So for everybody that hasn't been here or that's on the internet, this is basically Weiss-Serota taking the language that we've discussed and turning it into the written word, to see what the strike-throughs and underlying changes would look like. And what we're doing at this point is reviewing that to see if it faithfully reflects what we discussed in the motions that we made. So with that, I'm listening to comments from.
Well, I have one, and it's not necessarily. I will give me some leeway while I explain my process. I looked at on page 1 the how we're going to go about in that initial election, staggering the terms. And I questioned, why is a person running unopposed automatically going to have 3 years, which led me to Article 8 and also looking at some state statutes. I answered that question and understand why that needs to be like that, considering the language of Section 8.6 of the Charter. But then that led me to the question of Section 166.031, subsection 6, which says, each municipality shall, by ordinance or charter provision, provide procedures for filling a vacancy in office caused by death, resignation, or removal from office. We did that. But that provision goes on and says, such ordinance or charter provision shall also provide procedures for filling a vacancy in candidacy caused by death, withdrawal, or removal from the ballot of a qualified candidate following the end of the qualifying period, which leaves fewer than 2 candidates for an office. So Section 8.6 pertains to when there is only one person who qualifies to put in for a seat. They're not even on the ballot. They're automatically deemed elected. So that's what answered my question here. But what we don't have, and I could not see that our original charter had a provision that's required by law, which is what happens if post-qualification in a seat where, let's assume 2 people were running, one person dies, what happens? Because it seems like there has to be some sort of filling of a vacancy in the candidacy that has to be in the state charter pursuant to this statute.
John.
Can you hear me now?
Yes.
Oh, there we go.
Were you able to hear what Susan was saying as far as where she sees there's a missing piece in our charter?
Yeah, so it's not, as I recall, let me pull up the statute. The statute says it has to be in the charter. It can be by ordinance as well. So it doesn't necessarily have to be in the charter. Doesn't mean it can't be in the charter.
Well, the rest of it, sorry, John, to cut you off. I saw that, and if it's in ordinance, then that's an answer. But it also says that such ordinance or charter provision, and because the rest of it's in a charter provision, that's where the second part of my concern is. So I guess the first query is it an ordinance anywhere? And if not, then we need to do something. And even if it isn't an ordinance, do we need to pull that ordinance into the charter so it's all in the same spot under the statute? Twofold. Sorry, now go ahead and I won't interrupt.
So my interpretation of the way that I'll have to look and see if there's any, I don't think there's anything in the code. I just want to make sure that everybody was aware of what the language was. My interpretation of how our charter is drafted is that if somebody passes away and nobody is elected, that would create a vacancy in that position because the other person's term would have ended and you would now have a vacancy after the election and that the council would then appoint pursuant to the vacancy provisions. I have absolutely no issues if you guys want to put language in there making that clear or suggest something else. I can easily draft that. That's not an issue.
That's not the issue, John. We have that language. That's what you have put in here, and that we discussed at some length about the 6 month, 50%, not 50%, and when it's going to be appointed, etc. This is for before an election, so after qualifying in August, before the November election, in a two-person race, one person dies or otherwise becomes disqualified. How do you fill a vacancy in the candidacy before the election? What do you do in that circumstance? Not if they die after November election.
So the question would be, could somebody jump in if you're down to one candidate before the election after qualifying and one person withdraws, passes away, and you're down to one candidate, would you be opening it back up to have another candidate to get in?
Well, and I guess that's the question.
Because that's where I'm trying to figure out where this ends up going.
This is the language of the statute. Such ordinance or charter provision shall also provide procedures fulfilling a vacancy in candidacy caused by death, withdrawal, or removal from the ballot of a qualified candidate following the end of the qualifying period, which leaves fewer than 2 candidates for an office. That to me says you've got to address this somewhere. In everywhere else we're addressing it is in the charter. If we already have it in an ordinance, I'm not saying whatever we have is wrong. I don't think we have it, but do we have to have this?
Didn't we already have a similar situation?
I'm not aware of that. In fact, what I think, if I recall, this was prior to my time, is my recollection is that when Councilmember Rosenthal was originally elected, this is exactly what happened. There was an opponent who passed away, and I don't know how the village treated it. My belief is that they treated it as being unopposed. But we do not have anything in the ordinance or charter as far as I'm aware.
Yeah, I guess my question is, was that treatment proper given the statute, number one? And number two, is that written anywhere? And if it is proper but simply not written, if that's what the people want, then we need to codify it.
His name stayed on the ballot. I recall that. The name was never removed from the ballot. And I think he ended up getting more votes than Henry did, if I recall correctly.
Yeah, right? She would not release the total count, but the word was that he actually had more votes. But I think my recommendation would be this.
I just want to comply with the statute.
No,
that's it.
And my recommendation would be this. As we've done with a couple of other items, we make a recommendation that this be looked at and that by ordinance, this needs to be fixed if there's a deficiency.
Okay, I'm just saying that it looks to me like since the rest of this is done with the
I
charter,
know you like to keep it all in the charter.
That it may have to be. That part's vague, but
well, here's the nice thing: we can make that recommendation. These are all recommendations to council. When council brings this up, that will give Weiss-Rota more time to research it, and then they can recommend it go into the charter. Or we could just say, if there is a deficiency, we'd like to see it amended in the charter to be consistent, and I'm comfortable with that. And if there's not a deficiency because they've got it somewhere else in another ordinance, then we leave it like it is.
Fine.
Okay, can I get a motion that we recommend that the village council review the ordinances to determine whether this issue has been addressed in ordinance, and if it has not, that appropriate language be added to the charter to address the Chapter 166 issue, so that we stay consistent with keeping everything in the charter. Can somebody make a motion like that? I know you can.
So moved.
Okay, so I made the motion and I've got a second.
Okay. Do you want me to restate it?
Yes, do it. Come on.
Okay. I move to recommend to the council that the charter and applicable ordinances pertaining to candidacy be reviewed to confirm whether the village has an ordinance or charter provision that would comply with Statute 166.031, subsection 6, and in particular the last sentence pertaining to candidacies.
Do I have a second for discussion?
Second.
Thank you. At this point, I'd like to open up public comment. And barring any public comment, then we can take a vote. Thank you. Do we have anybody that wants to comment on this one?
There are no hands raised on Zoom.
Sue, Joe?
I think the purpose of this committee is to give the direction to the council, and this wouldn't be giving them direction on what to do to fix this problem. What do you do if there's only one candidate left?
I think we are giving them direction. We're saying that if there's a deficit in our ordinance, that we address it through a charter change to be consistent and keep all of this in Section 8 of our charter. That's how I understand it.
So to correct the problem, though, do you have a new election, you open up for new candidates, or you accept that there's only going to be one candidate? What happens if there was only one that filed and he dies? Just seems like you need to...
I tend to agree, frankly, with Sue that the way that this statute is written suggests that you have to have at least two candidates on a ballot if two candidates were qualified and then something happened before the election. Otherwise, one would have thought that it wouldn't have emphasized that you have a qualifying period which leaves fewer than two candidates for an office. That is, if three people had qualified and one died, not a problem. But if three people qualified and two became disqualified in any fashion, then you've got an issue, which seems to suggest that this statute wanted an actual election. How to fix that, is a different question, but I think in steps, it first has to be determined if we have this stopgap in an ordinance. It's not in the charter. If we don't, what would a proposal be is the next question. And yes, it would have fallen under our purview, but I'm not sure that, what do we do?
Well, I think our recommendation...
Do we allow, opening up the qualifying period? I don't think you can do that by state statute.
Yeah,
so.
I think what our recommendation, if I take it another shot at it, is to be consistent with Florida statute. And if it's not addressed by ordinance already, to have it addressed by a change to the charter, to be consistent that Section 8 addresses the whole kit and caboodle.
In a manner, obviously, that would comply with the requirement.
Right, and I'm comfortable with that. So we have a motion and a second. Marnie, can you call the roll, please?
Vice Chair Raffanello?
Yes.
Committee Member Roth?
Yes.
Committee Member Lalonde?
Yes.
Committee Member McVeigh?
Yes.
Committee Member Young?
Yes.
And Chair Harris.
Yes.
That motion passes 6-0.
Okay, so we're at the end of the agenda, and I would just like to take a second and first thank everybody that volunteered for this. Appreciate having your Monday and Wednesdays nights, and I feel good about what we're recommending. I think they're common sense. I know not everybody in the and the town agrees. Tom, I listen to your show sometimes, so I get it.
I listen to him a lot more than that.
But you do. You can't get away.
I'm so sorry.
Nor would I want to.
But I really appreciate. I think we put some solid work in, and I think our recommendations are good. I don't know if what the council will do with them and what the public will do with them, but I feel that we put a lot of time and effort and thought into them, and I'm proud of the work we did. I would also like to thank John from Weisserota and Lynn from Florida League of Cities for their input in making this process a lot better by giving us some background that we didn't have. And of course, you couldn't do any of this without our staff. Frank in the booth, Marnie, Jennifer, you guys are great. Really appreciate you donating or volunteering or not volunteering your time to do this. I hope Ron gives you a couple days off to make up for it. But I really do appreciate all the work you put into it. And for everybody that participated in the public participation, I really appreciate your participation. We did have some really good input throughout the couple months that we've been meeting. And I thank you again. And with that, I'd like a motion to adjourn.
So moved.
Thank you.